Hello, ladies and gentlemen. Welcome back to Insurance Education. I am Raymond Macmillan if you're joining for the first time. In today's video, I'd like to tell you about fraud in the insurance industry. Now, from our texts, if you're doing the CI exams, it is estimated that fraud costs the insurance industry in the UK just over £1.2 billion annually. And you could understand, ladies and gentlemen, some companies do not turn that over a year. So that could be the position between being bankrupt. And it's not just the individual fraudsters, but you have these organized gangs that are crashing high valued vehicles. Therefore, the average payout is a lot higher. But where I want to take you today, ladies and gentlemen, I want to take you back to 2002, and forgive me, I'll have to do a bit of reading. There's a case called Konstantinos Agapios versus Ian Charles Agnew. It's 2002 case. The judge then dealt with a situation where a client presented a claim. Part was innocent, but part was inflated and which accounted to fraud. And then that judge quoted a case in this, it's called the Star C case if you want to look it up. But it was in a case of Manifest Shipping Company versus Unipolaris Shipping. And the judge said, no, the fraudulent insured must not be allowed to think, let me try something. If I gain, fine. And if I don't gain, I lose nothing. And that was the position where an entire claim had to be declined if an element of fraud exists in the claim. That existed for about 12 years. Listen to another case. I laughed when I listened to this, when I looked at this one. It's in the case of Versloot, Dredging BV versus HDI Girling Industries, Verchis Chong, AG, and others. It's otherwise called the DC Merwestone Case, and that was 2014. So look up the DC Merwestone Case 2014. And the judge there reversed the decision. He said, once no one lost and no one benefited, if a client committed fraud, in the instance of processing a claim, that's okay, provided it wasn't substantial and it really didn't affect you paying the claim. But in my own humble way, what about utmost good faith and good faith? And that's the position of the law, ladies and gentlemen. Therefore, if a client knows their rights and they've submitted a claim to you and part of it was fraudulent, and you try to deny the entire claim on that basis, they may have legs to stand on to challenge you, the insurer, the claims manager, that you ought to pay my claim. They've got the case law to back them. In addition to that, the Financial Ombudsman Service, and you know that's the final appeal body you can go to if you're unhappy with an insurance company. They are somewhat agreeing with the ruling in the DC Merwestone case in 2014, because from our text it says the FOS, historically they thought that the insurer's stance on fraudulent claims was a bit harsh, and they are agreeing that it makes no difference. I just read it for you. In their view, this is the FOS, is that the fraudulent act or omission makes no difference to the insurer's ultimate liability under the terms of the policy. It should not entitle the insurer to forfeit the policy or avoid the claim. That's the law for you. If you're doing the CI exams, this is right out of your CI text and may turn up in this year's exam. I trust this was helpful to at least one person in your district, in your territory. Look again at your fraud condition and be aware that the insured now have rights even when they commit fraud against you, the insurer. May we invite you to click the like button if you like this video. If not, why not subscribe to our channel? Thank you, ladies and gentlemen. See you next week if all goes well.